I would just roll on it. I'm recording it. Measure twice, cut 3 times. Gentlemen.
Wow.
I know they hate me. What can I say?
I have a feeling we're
They
not.
know it's a temporary thing, I guess. Alright, sounds good. Thanks a lot, Bob. Yep, bye.
Wow, I'm getting this stinking suspicion that we're not getting a feed out.
I don't think so either. I think what you have to do is tape a lav up there usually.
I guess what we're
Actually, I guess what we usually do is we just put it up on the windowsill over here.
Well, yeah, it's usually where it reaches.
Yeah. I mean, unless you gotta go grab your extended boots, I don't know.
No. Well, I mean, like, it depends on the reach of what I could stand on this chair for. But.
This is where teamwork comes in. You stand on my shoulders, I stand on your shoulders.
I can only imagine that from their perspective and there.
Make it happen.
And then someone takes a picture of it, puts it on the internet, and then the caption is, "This is why women live longer than men."
4 million updates. Here's a Reddit gold stranger. We'll call it a day.
Let's see what I
You
can
could
reach.
actually just make a whole thread on that. Why women live longer than men.
Yeah, I'm gonna go with. I'm not gonna reach that because the last thing I want to do is like step on this. So. I just fall right on that. Like I don't want to do that.
I got distribution over here for you, by the way.
All right, let me get a longer cable. I'm just glad he's probably gonna. Oh wait, no, never mind. I was about to say he's not in the position where we can see his face, but he's gonna be over there. Cause every time he like looks back in the crowd and makes eye contact, and like.
Well, they said they said he's pretty for sure they're gonna be on the stand today. So.
Well, he was on the stand for like an hour yesterday and went nowhere.
Well, here it comes again today.
Yeah, and today he's gonna be back on his usual bullshit.
Yep. I just need to clip it.
Here, I'll stand down here and try to catch you in case.
I can't reach.
You're taller than me, so I'm not gonna be able to reach. We should get the sheriff to come out here and do it for us.
Well, it'd be nice if they had a step ladder.
Yeah, real quick, you put me into there. That's a little more safer.
I can do that. The problem is I don't have a tape to keep this up here.
I don't either, unfortunately. You got tape?
In my car.
Right, that's the inherent problem with mine. Yeah, it's like if I just step out of it. Alright, you'll at least sit there.
That works.
Unless someone slams the door really hard.
Yeah, no one breathes too hard.
I want to hope that part, the slamming. Good.
Well, one of you fine gentlemen.
Yeah, I got you. There was quite a contraction over here.
Let's get that here. Let's feed it underneath.
Makes sense. You're clear.
They should start selling popcorn. I think that'd be a good way to get some revenue.
I like I do like the in front of the desk there, the Mardi
Tinsel?
Gras.
Oh.
tinsel.
I think what really killed it for me was the Comic Sans on the notice out there, really helped with the feng shui, you know?
What school did I see that at recently? we were at some. I was at some school, and like they had like. Oh no, it wasn't even a school. It was Delafield City Hall.
Yeah.
Their labels for the library and the City Hall part were in Comic Sans. I'm like, who made this decision?
Graphic design is my passion.
He's just missing a frog.
It's so good. It's so good. So I guess what's gonna happen is I think the jurors are gonna come through the back and walk in. Is I think what I heard them saying. Because the jury room's over here to the right.
I arrived as they were all gathering down in the lobby, and every single one of them was just like this. And they're tired.
I feel that way too.
I'd be mad if I had to come in on my weekend to be a juror. Oh my god.
Yeah, and I get it.
Oh, all right. Good morning.
Just slide this out over here.
Do you need me to move stuff over for you?
No, I just wanted to. This way, my right hand doesn't have to go through this thing.
How come the jury gets all those comfy chairs and we get this?
For real. Dude, like some of these TVs in here, I'm like, what the hell? Like this one up here? Dude, tell me that's not like
It's
a,
like
like a 70s TV, bro. Like,
It's a little too new for the 70s. More like maybe
Yeah.
80s, 88, 89.
just kills me. I was here for that one cop that was using the cameras to spy on his girlfriend or,
Oh, yeah.
or you know whatever. Dude, the audio system in that one, like, literally is falling apart. Like, I went to go tape my mic to the speaker and it was like crumbling as I touched it. Something like that.
Oh, this is Ramo's courtroom, correct? Sanders? Okay. Got my laptop just in case I was gonna have issues. Oh. Okay. Okay.
Have that right away in case anything goes haywire. Oh shoot. Internet's down to
It was directed towards me.
No, everybody. We're in
Okay, cool. Then I guess we're not live streaming this time.
Dude.
It's Timothy Olson.
You know, my family contacted that.
It dragged down a lot yesterday, and with the
It's
snowstorm
possible they
coming
put
up
it
on
on
Monday,
there. I ordered way too many,
Oh,
and then I realized it's just the 4 of you
Oh,
guys.
okay.
Because you said you know that.
Oh, no,
like
no,
you said
no.
it in a way like I expect you know.
On Saturday?
I don't know. This is my first time being in court on a Saturday, so.
I think they can.
I'll just I'll keep it up and I'll keep it up.
Can you email Sergeant Wilborn?
No, that's cool. We're good. We're good.
That was submitted yesterday.
Take attendance.
State of Wisconsin versus Timothy Olson Jr. Case number 22 CF 4696. Appearances, please.
Timothy Olson, pro se, appears in person in custody in street clothing. I would note he has a different shirt from the one he'd been wearing earlier in the week. Also appearing at council table is standby counsel John Vasilevsky.
All right, good morning to everyone. Bill, you can hear me? Okay. Good morning to everyone, and thank you for being here today on a Saturday. I understand all the jurors are here. And what I'm going to do is bring in the jurors and take attendance, and then we'll proceed. I'm reminding you, Mr. Olson, that you've already incurred one violation against the court's rules. As to your testimony, if you incur another one today, I will forfeit your right to testify, and then we'll proceed to the jury instruction conference and verdict forms.
Your Honor, may I?
Oh, no. I'm not done. Just misplaced my note. But because we're in a new courtroom today, things are sort of disorganized. I'm going to try to be helpful today in reminding you that the rules relative to your testimony, which is allowed in the narrative form, is first and foremost to keep it relevant, and that secondly, if there's an objection, whether by you or by opposing party, that you are to wait for my ruling before you speak. There may be occasions when it's not necessary for me to entertain short, succinct arguments of the parties, and I'll just immediately rule. Other times I may inquire, but you are to wait for the court's direction on that. Additionally, there is no arguing and there is no commentary allowed, even when you're testifying in a narrative form. For example, as I stated yesterday, the jury does not need to hear your thought process about what you're going to say and why you're saying it. If you have something to say relative to your testimony, just make that statement. Those are the rules. Is that clear, Mr. Olson?
Yes, and then could I say something, please?
Okay.
So the defense has not rested yet, and I'm considering calling a couple of witnesses, if that's okay. I would definitely like to recall Detective Zalewski, and I would also like to be able to call DA Sadowski to the stand, since she had off-the-record communications with my private investigator, a past relationship with DA Sadowski, and communications off the record with other court personnel, deputies by DA Sadowski, about my case.
Okay, so.
And also, sorry, one more thing, I didn't mean to interrupt you. I do have another motion for dismissal and mistrial with numerous issues that I didn't raise yesterday. Some are based on some of the issues yesterday, but I'm also asking that this motion not only be submitted into the record and heard before trial is over, that they also be forwarded to Chief Judge Carl Ashley, DA Kent Laverne, Sheriff Danita Ball, the FBI.
Okay, I'm going to stop you there because we don't have a whole lot of time today. I've only been authorized to have this room until noon. So I'm not going to pretend like you are the judge and you can take direction of how this case proceeds. I'm going to say that once, and I'm going to make it very clear, okay? So yesterday, there's a process and procedure to everything. Yesterday, okay, after state's case in chief, pursuant to procedure, I entertained motions. The court made a decision, we move on. You'll have another opportunity to motion the court, but we're not there yet, okay? So do not go on the record with those motions because now is not the time. All right, let's bring in the jury. I understand that given what you just indicated to me, Mr. Olson, you do have one witness in addition to yourself, and that being the detective. So after your testimony, I'll allow you to call that witness. And we'll proceed relative to your request to also call the prosecuting attorney in this case. What case law or legal authority do you have to say that you can do that in this very trial?
So I would
Until you can provide that legal authority that allows you to do that, the answer is no, you're not allowed to call the prosecuting attorney in this very trial.
Okay.
That is all. That is all.
Yeah.
I've addressed the witness lineup relative to timing, and now we're going to go on the record. Let's bring in the jury. Put your hand down, Mr. Olson. We're done. Oh, I'm sorry. We should have had Mr. Olson set up first. I'll take attendance, have him walk back a little bit, for a little bit, and then, actually, now that I'm serving the room. There's no witness box, is there? Oh, okay, right there. Can you let Deputy Bruce know? Don't bring out the jury just yet. Okay, so, yes, could you? Let's have Mr. Olson staged for testimony. Okay. We are outside the presence of the jury. Let's have Mr. Olson staged for testimony because he was in the middle of his testimony yesterday, and that's where we will begin. So, Deputy to, Mr. Olson to the witness box. Does it have a?
Are we off the record still? Or on the record?
Okay, you want Deputy to come back then?
I don't know. I don't know. Your Honor, are we on the record?
We are on the record, but I'm not allowing you to put anything on the record at this time. I forgot. We really should stage Mr. Olson first. Yeah. Yep. I'm so wherever they want. I'm going to take their attendance again and with a new seating chart.
Your Honor, I just had a quick question, please.
Mr. Olson, stop. Let me remind you the rules of decorum. Okay. You're to follow instructions from the bailiffs. You're to only answer questions asked by the court.
Not one pro se.
You need to be respectful. Okay. And no outbursts when not recognized by the court. I'm not addressing you, so do not make any statements. Okay, now we're ready for the jury. And the exhibits are ready? Okay. Deputy, I don't know if Deputy Bruce told you, but with exhibits, if it's being used, you'll take the exhibit, or whoever, whether it's you or Deputy Bruce, show the opposing party, and then, no, I don't think it's necessary. But the deputies will assist with moving the exhibits between the opposing party, the examining party, in that fashion. Yeah. Yeah, that's correct. Consistent with yesterday. Just paper exhibits may be at the witness stand. We're on the record, but no one is allowed to talk. We were just figuring out logistics, okay? Yes, we're ready. Bill, you ready? We're on the record in the presence of the jury. Good morning, members of the jury. Again, I want to thank you for your patience. I thank you for reporting for service today. We're in a entirely new courtroom, and so if you could just give me your juror number, and I'm going to take your attendance on this new seating chart, starting with the first row from my right. Please, when you return from break, to sit in the same seat. And now that I have attendance, I know where all of you are located. Also, just be a little patient with the parties as we go through this process, because this is a new courtroom and it may take a little bit of time for everyone to get used to where things are. As you may recall, yesterday, Mr. Olson was in the witness stand testifying, and that's where we will pick up. Mr. Olson, at this time, we'll have you sworn in, and then you can commence your testimony.
Good morning. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. And just for the record, could you spell your first and last name?
Okay, continue. Okay, and that exhibit number is? Mr. Olson, make sure you speak into the microphone. It should be on.
Oh, it is. All right. So I don't remember what time it was, but apparently it was around midnight that she created this account and phone number for us to communicate with. And then somewhere after that, I thought it was probably maybe after 2 a.m. I'm not positive though. It could have been right around this time that it states here the UTC time of 6:49, which would translate into somewhere after midnight. But I think it was quite later than that. Betty did text me through this Google Voice number. And asked me where I was at and if I was coming back. She also stated that wanted to make sure that she said, you didn't tell Rex that we knew each other, did you? There was another text indicating that her credit card had a $25,000 limit, which I would not have known without her telling me. When I got back to the car, when she texted, I wasn't even aware that she texted. She showed me the text on her phone saying that she had texted me and wondering if I had got them through the Google Voice. So this is why I know the texts were in her phone. Oh, also, she had informed me that the next day she had to meet her brother for Thanksgiving at Mater's.
Sustained. Next question. I'm sorry. Continue your testimony, please.
Okay. So we were going to meet back up after her meeting with her brother at Mater's. Which I forget what time that would have been. She was going to go early as possible and then come back to meet me. And we were going to go out of town. We didn't necessarily know where, but just somewhere like northern Wisconsin, maybe. As I said last night, we went, yesterday, sorry, we went to several locations. Sometimes we paid with her card, sometimes I paid with cash. I did leave a couple of times from the car, venturing out. She just stayed there in the car. I don't know if she drove around at all, but especially when she texted me. Throughout the night, she also made me aware that she didn't want me to leave. She did inform me that she had power of it.
Sustained.
Okay. I knew that she had power of attorney over her brother's financial affairs, medical care. From that night and other.
Sustained.
Your Honor, I object. It shows that I had.
The court has made a ruling. Continue.
So sometime early morning, we had an argument. Wasn't like no violent argument or anything like that. Just disagreed on things, and this did happen throughout the night. And at some point was when I decided to just get out of the car, and she was going to go visit her. She was close to going to go visit her brother anyway around this time. She was going to drop me off somewhere else, but because of the argument, I just got out of the car and she drove off down whatever road that was. It was on the map. So before that, let me think. So before that, we had planned, like I said, on her. She was just driving me up. It wasn't far from where I got out at, but it was just to the point to where I just wanted to get out of the car. And we were supposed to meet up soon after that. She was going to Mater's to meet her brother.
Okay. Sustain.
And then she was going to come back to get me.
Okay, sustain. That part of the testimony is stricken from the record.
I object to that.
Okay. Members of the jury, we're going to take a break, and then we'll have you back when we're ready. Okay, I remind everyone this case is not concluded. You're not to talk about this case, and you are not to conduct your own research. Which happened at least twice already this morning. And you've only been on the record for the less than 10 minutes. In addition to that, you did not follow my rules relative to your testimony, okay? And so you were argumentative. You want to have the last word, as you often try to do. Therefore, you violated the court's rules of decorum and the court's rules relative to your testimony. You have forfeited your right to testify. You may now be returned to your chair, and you're going to be allowed to call your next witness. Okay. Let's get off the record while the deputies do that. All right, thank you. That is
I would
for the
also like
record.
to place.
Mr. Olson.
Can I place something on the record?
Another violation of the court's rules of decorum. Okay, we're going to go off the record, and you're going to be returned to your seat, at which time we'll come back on the record. The court's rules of decorum.
I'd like to object to not being to testify about the other allegations. I did not, I was just objecting to your ruling. I wasn't going to argue it, just show my objection on the record. I was not trying to break any rules of decorum or anything, you know. I just wanted to make my objection known. But I mean, I clearly am objecting to my right to testify on my own behalf. The jury does not even know my side of the story for these other allegations, and I would definitely declare this a mistrial and for the clear prejudicial and biased narrative you're displaying towards me constantly through the media in front of everyone. This is clearly prejudicial and judicial misconduct beyond. It's bizarre. It's not even grossly shocking and shocks the conscience. It's beyond that. It's bizarre. It's you're clearly siding with the DA and you're allowing her to say whatever she wants, and I don't get to say anything. So, I mean, I guess we'll just continue with this legal lynching.
We will continue. Not everything deserves a response, so I'm not going to respond to that. The record is quite clear as to what transpired. We're going to bring in the jury. After they're seated, then you will call your next witness.
And my motion then?
Yes, we're ready. We'll discuss this more on the record during a break. I'll allow it. You may answer the question if you know it.
No. Through your investigations, was there any proof, video of Mr. Olson forcibly physically forcibly restraining anyone, not only Betty, but anyone in throughout this investigation.
I'm going to sustain that objection, but with the caution that, okay. Actually, it's just going to be better if I remove the jury and then we'll bring you back, okay? Members of the jury, this case is not concluded. Do not talk about it. Do not conduct your research. The jury, Mr. Olson, the state is correct that was a leading question, but to the extent that the court can appreciate that you are pro se and you're not a trained lawyer, nonetheless, you're still expected to know the rules. Yeah, I think that's helpful in just us moving along. As you may recall, and I said it before, that it's not an exhaustive list of things that you can and cannot do during examination. And you are on direct of this witness because you are calling him. That on direct, you cannot ask leading questions. And I want to make sure that you understand that. It's been said so many times, but for purposes of ensuring that you have a fair opportunity, I'm reminding you yet again of the rules. And again, you are expected to know the rules. Is there anything about what I just said and how I explain things that do not make sense to you relative to your direct examination of this witness?
So, in my defense, Attorney Wazlewski just informed me of the difference between questioning him as cross-examining or as a direct witness. So I will do my best to make sure that I form the questions in the manner that they're supposed to be formed. If they are not formed in that way and I accidentally form them another way, the DA is more than welcome to object, but I will try and keep them that way. I would not do that purposely.
Well, and which is why we are having this discussion on the record outside the presence of the jury, okay? Rather than admonish you during the course of your examination, I wanted to redirect your focus to what's permissible and what's not permissible. Also, besides the fact that on direct you cannot ask leading questions, had this witness been called adversely, noted as so on the record, things could be a little bit different as well. I recognize that there are some things here that could, within the court's discretion, that the court can allow, and that's why I want to have both parties aware of where I'm coming from relative to all of this, okay? But going forward, do you understand the boundaries by which you're supposed to operate? Mr. Olson?
Yes, but
okay, that's all.
Yes,
I just need a yes or no.
I mean, I don't have a lot of experience with.
Okay, we don't need to rehash history here. Okay, let's bring in the jury. We're ready. We are still on the record, but no one is allowed to say anything on the record at this time.
Like when I'm asking about the video, or if he has any proof.
Oh yeah, I knew Mr. Olson?
So, according to Judicial Code of Conduct 60.04, you are to allow me to speak since I have legal interest, especially since I'm self-representing, and you're also not to show prejudice or bias in front of the media or any court personnel in the courtroom.
Mr. Olson, if that relates to your request that the court declare a mistrial, I've already explained there's going to be a point in time for you to do that. Okay, now is not the time. Mr. Olson, please continue your direct examination.
So, Detective Zalewski, during your course of this investigation, did you or did you not find any video evidence or any other proof of Mr. Olson ever having a gun?
No.
Detective Zalewski, through your investigations of this case, did you or did you ever not find any evidence, proof, video of Mr. Olson physically restraining anyone, including Betty Hannell?
Proof of you restraining anybody? No.
Through your investigations, did anyone ever witness Mr. Olson actually taking anything from anyone? Did you or did you not?
Objection, confusing. Okay. Sustain, re-ask that question. you have any more questions, Mr. Olson?
Yes, Detective Zalewski, through your investigation, did you or did you not find any proof of Mr. Olson forcing Betty Hannell to do anything?
No.
Detective Zalewski, through your investigation, did you find any proof of, did you or did you not find any proof of Mr. Olson forcing Betty Hannell to drink anything?
Yes, through Betty Hannell's statement.
Did you find any video evidence? Did you or did you not find any video evidence of Mr. Olson forcing Betty Hannell to drink anything?
No.
Did you or did you not find any controlled substances in any of these bottles that you tested?
No.
Through your investigation, Detective Zalewski, did you or did you not find any video evidence that would prove that Miss Hannell and Mr. Olson were not actually together?
Objection, compound question. Sustained. Ask your next question.
So, Detective Zalewski, how many investigations have you done into kidnappings?
I don't know the number off the top of my head. I have investigated kidnappings before. It's not a common investigation.
I'm sorry, did you say you have investigated?
Yes, I have.
No number off the top of your head?
I don't know the number off the top of my head. It's not a lot.
Less than 5?
It might be around 5.
Okay, out of those investigations, how many times did you not use an interrogation of a defendant?
Objection, relevance. Sustain.
Okay, of those 5 or less alleged kidnappings that you've investigated, how many did you not completely investigate video evidence of?
Objection, relevance. Sustain.
May I object? And I just wanted to object and maybe rephrase the question so that it can be asked properly, or?
Yes, you may rephrase the question. All right, members of the jury, I'm going to release you for a break. Plan for about 5 minutes, and when we're ready, we'll bring you back. I remind everyone this case is not concluded. Do not talk about the case and do not conduct your own research. Okay, we're outside the presence of the jury. Mr. Olson,
Yes.
in between questions, not every question, but in between most of your questioning, you're taking up time and you're waiting about a minute, sometimes a little less than a minute, but the last one, you waited a minute before you move on. So we're gonna go off the record. I'm gonna give you a little time, not a whole lot of time, to collect your thoughts and do what you will in the organization of your questioning of this witness. But what I'm not going to allow you to do is to use time in this manner.
Okay, may I?
It's permissible for you to think on your feet, but you taking about a minute in between most questions that you ask is just not going to be conducive, okay, to me moving this case along.
Okay, Your Honor, I have a quick question. So I clearly think that the manner in which this was investigated is relevant because it shows that the detective knew that there was not really a crime happening, because a serious allegation such as kidnapping, they would want to investigate any possible video, especially to see if someone was physically harmed.
Mr. Olson, how this detective investigates other cases has no relevance to this case. Maybe he did a great job on the other cases, maybe he didn't. But what does that matter in this case? It's about what he does or what he did in this case that makes it relevant. Does that make sense?
Sure, but
Beyond explaining it that way, I don't want to cross any lines and to make it appear that the court is advising you of how to formulate your questions. But in the interest of time and by way of example, I've explained it that way, and that's the best I can do. I'm going to go off the record so that you can have that time. Plan for 5 minutes. You should have had this done already. Okay, we're off the record. Now it's 9:42. And same appearances before with State and Mr. Olson and standby counsel. Okay, so Mr. Olson, your time would have ended at 9:47, but you had a little extra time, so we're going to now bring in the jury. We're ready. Okay, welcome back, members of the jury. Mr. Olson, please continue.
Detective Zalewski, through your investigations, did you or did you not find any video evidence of Mr. Olson actually committing a crime?
Objection. Relevance.
Well, I don't know that that would be the right basis for the objection. Response?
Well, I object.
Okay, well, you're asking for a legal conclusion, which the witness is in a position to make, so the objection is sustained on that reason. Next question, please. Ask your next question. Mr. Olson, ask your next question.
Oh my God. During your investigation, Detective Zalewski, did you or did you not find any video evidence of Mr. Olson actually committing Did you ever find any video evidence of, or did you or did you not find any video evidence of the burglaries that were alleged?
Can you repeat the question?
Through your investigations, did you or did you not find any video evidence of Mr. Olson being involved in a burglary of the RV that is alleged to have happened?
No, I did not find any video evidence.
During your investigation of the burglary of the alleged burglary of the garage, did you find any video evidence of Mr. Olson being involved?
No.
Ask your next question.
Oh my God. That's all I have for the detective, Your Honor.
Ross?
Detective, do you have to be physically touched to be restrained?
No.
No. Could you go over a couple other ways that someone might be restrained without being physically touched?
It could be the passenger in a vehicle unable to leave.
Would it be perhaps if someone alleged to have a firearm, would that restrain another person?
Yes.
Well, there wasn't video evidence of the burglaries, were there other types of evidence that you were able to locate in this investigation?
Yes.
Could you tell us about some of the evidence regarding the garage burglary?
As your testimony, the garage burglary, there was a red bike in the garage. That's the same red bike that Mr. Olson had in his custody when he was observed by Officer Frusti at 35th and Rawson, where he then fled and dropped the bike, where it was later recovered.
And then regarding
Objection,
evidence,
Your Honor,
Objection to question, or
to his response that
you don't get to argue with the witness. You can object to the question. Let's move on.
and then regarding evidence of the RV burglary, was there any evidence located regarding that a recreational vehicle was burglarized?
Yes.
Yes. And was that evidence the items that were found on Mr. Olson when he was arrested?
Yes.
I have no further questions.
Redirect, or in other words, follow up to that.
nothing further for the detectives, Your Honor.
All right, thank you, Detective. You may step down.
Thank you.
Defense, please call your next witness.
I would like to call DA Sarah Sadowski as the witness, Your Honor.
Not allowed. Anyone else? Does defense rest?
Just a second, Your Honor. So subject to filing of my motion, I didn't want to rest until that was placed on the record, Your Honor.
I've already explained procedure relative to when I'll take that motion. Does defense have any other witnesses to call?
No.
Okay, so for the time being, defense rests, subject to rebuttal, is that correct?
Yes.
Okay, all right, thank you. Does state have any rebuttal witnesses? No. Okay. So members of the jury, I'm going to release you for a extended break, planned for about 30 minutes. There's some things I need to take care of, and then we'll bring you back when we're ready. Okay, I remind everyone this case is not concluded. Do not talk about the case and do not conduct your own research, not post about it. Okay, thank you. Outside the presence of the jury at this time, now that we have reached a point in the process where both parties have rested, Mr. Olson, motions if any.
Yes, I have it's a motion to dismiss based on many issues and for a mistrial and requesting an investigation into the phone download specifically and prior to the end of trial.
I'm gonna stop you there, and I'm gonna try to direct you a little more than give you free range, because I allow you to do that yesterday. You wasted a lot of time. You have two motions before me. One is for dismissal, and this dismissal I imagine is related to the close of all evidence. And so what's your basis for the dismissal, your motion for dismissal? And I'll remind you that at this point it's sufficiency of the evidence. What's your basis for your motion
So-
for dismissal at the close of all evidence?
So besides this one,
Okay, let me break this down. The way I understood what you just said is that you have two motions, one for dismissal and one for mistrial, correct?
yes, they're together. They're together in one motion.
I'm telling you to separate them, okay? So there are two motions, there are two asks of the court. One, you're asking me to dismiss the case, and two, or in the alternate, you're asking me to declare a mistrial, correct? Those are the two things you're asking of me.
Yes.
Okay. Now, as to your ask that I dismiss this case, what is the basis for that? And I remind you that it's sufficiency of the evidence. So let's hear it. What's your basis?
Okay, so the for count 4 again. I'm entitled to face the injured party, and I've looked this up. And caretaker, she claimed to be caretaker of her brother. That does not constitute ownership of the property. The injured party claiming damages or injury has to be present. That I have a right to face my accused under the 6th Amendment of the Constitution, and that person was not available in trial, was not ever able to be questioned. And again, I did ask his sister if she was ever owner of that property during that time. She was not. She's not power of attorney, anything like that. She was only taking care of her brother. That does not constitute ownership of a dwelling, and therefore those charges must be dismissed. I'm also, there's numerous, I wrote everything in a motion so I wouldn't take up the court's time in this manner, but there are numerous issues here that are extremely important that I think that the court needs to look at. I believe that there should be a completely separate hearing on the complete Brady violation, as when I did get
Mr.
time.
Olson, I'm going to redirect you. Sufficiency of the evidence, okay? Stick to that. Given all the evidence that's come in, because both parties have rested, how is the evidence insufficient to sustain these charges so that the jury may deliberate?
So there.
You've explained count
There
4.
was-
What about count 1?
Count 1, there's no proof of any kidnapping.
Okay, and then count 2.
Okay, also on count 1, there's no proof that me and Betty Hannah were not together, and that we did not know each other.
Count 2.
Count 2, there's no proof of intent of using someone's card without their consent. In fact, it's just the opposite. We were together the whole time.
3, obstructing an officer.
There's definitely no proof of obstruction of an officer.
And then you spoke up about count 4 already. What
yeah.
about count 5?
So on count 3, I want to add that I was actually tased while going to the ground, and this would have been shown on the video. I've never been.
No commentaries.
Okay. And go ahead.
5.
And count 5, there's no proof that I did not know the defendant, and unfortunately I was not able to testify to the fact that I stayed in that RV for quite some time.
All right. Now give the state a chance to respond, and also if the state has their own motion. State.
Thank you, Your Honor. I think that there was sufficient evidence to allow all charges to go through. Betty's testimony alone covers counts 1 and 2. The officers counts 3. Counts 4, possession of property under 971.33. What's sufficient? It's that sufficient that if the time the crime was committed, either actual or constructive possession of the general or property of any part of such property was in the person to be alleged the owner of. We had Christine Endell testify to the fact that although not the owner, she was aware that no one was going to take the property, did not have permission to take the property, and that she was watching the property while her brother was incapacitated, and that is also constructive possession of the property. So I think we have that covered as well. And regarding count 5, I think that there was also sufficient testimony that Mr. Olson didn't have the right to take or remove or be in any of the garage. Or I'm sorry, count 4 was the RV, right?
That's correct. The
Yes.
motorhome trailer.
Count 4 was the trailer. So please
No,
switch.
count 4 is the building.
Okay.
And then count 5 is the motorhome, the
Count-
RV.
Count 5 is the motorhome. He didn't have any right to be inside of the motorhome or take the property out of the motorhome.
All right.
Oh.
Again,
Yeah.
as I indicated, at this stage, with respect to motion for dismissal, it is sufficiency or insufficiency of the evidence. I haven't heard the arguments of the parties. I'll start first with count 4, because that's where Mr. Olson started. But I agree with the state that given the evidence thus far, at a minimum, it is sufficient relative to the legal definition of ownership or possession. Thus, that count, there is sufficient evidence to move it forward. With respect to the other cases, Mr. Olson may disagree with the evidence. He may disagree with what the witnesses said, but that doesn't mean that evidence doesn't exist sufficient enough to submit the case to the jury. For all those reasons, motion by defense for dismissal is denied. Mr. Olson, now I'm going to direct you to your other motion, which is a motion for mistrial. Please place on the record your basis for mistrial. And I'm going to give you 5 minutes for that. Starting right now, it's 10:06. It is your motion, so I'll let you have the last word, but 5 minutes for you to put on the record your basis for that motion.
Okay, I believe the entire case should be declared mistrial because of the Brady violations. The 3 flash drives that I was given, or my attorney was given, I was given one by Attorney Bastian, 2023, and 2 here, and Attorney Wazowski can testify that none of those would function
Mr. Olson,
properly.
I'm going to interrupt you here for
Okay.
a minute, but you, yesterday, or the day before, I mean, this week is becoming a blur because of this whole entire circus. You already brought up your motion, and I entertained your motion for mistrial. Given everything that's transpired since then, is there new information to add to what you already made me aware of that I relied on in making my decision, which was a denial of your motion for mistrial?
Yes, I found on those drives since then that they won't open up because there's like some settings that were set on there for permissions, which clearly indicate malicious intent by someone, whoever made those files, and I could not open them up. Therefore, I have now, with the help of Law Library, enclosed them in an envelope so that they can be analyzed by DRP security services, who will analyze them to see how and when they were set up to the fact that I couldn't view them, and that there were things removed and blocked, and so there will be time stamps to prove that this was done prior to being given to me, and therefore violated my right and is a complete Brady violation.
But I thought that in court, in my presence, Attorney Wazowski gave you his copy of the disc. So what you had was Attorney Wazowski's copy, which in court, in my presence, the state opened and was able to open the Cellbrite download on her laptop. And again, it's a laptop, not a desktop.
Okay, so Attorney Wazowski just gave me his copy on the 4th day of trial, and when I took that back, it would not open there. So this is the problem with permissions. And I'm just recently finding this out from people who are experts in this type of thing, that it can be set so that it will only open up on certain laptops, not everyone's. So only certain users can open it. So when she opened it up on her laptop, not his, it's because there's permissions set for her to open it, not anyone else. She never opened up any one of ours. And the 2 that I have been given the two that we were given before trial wouldn't function, and Attorney Wazluzzi testified to that, and that is what is important, that I did not have discovery before trial. That is a clear Brady violation and should be automatic grounds for dismissal of all charges with
Your
prejudice.
next basis for mistrial.
And I was not allowed to access case law to provide for my motion yesterday. I was only allowed access to my flash drives, not the law library, which has been taken away from me from the tablet that I normally have in the jail.
I believe I heard that already. Continue
Okay,
on, please.
all right. So I need to re-add that 8 of the 12 jurors have talked about my case in the library. I mean, I'm sorry, near the elevator and near the stairwells, all through the hallways, and I've continued to be brought through the front of the courthouse instead of back routes, which normally are taken any other time I've gone to court except trial. DA Sadowski is also communicating on.
Moment. Okay, continue.
So, DA Sadowski is also discussing the case on her phone with friends, family, etc. in the middle of trial. From what I am also, let's see, and because of this juror misconduct, they are all now aware that I have requested mistrial for juror misconduct. This has been all over the news, and this has definitely prejudiced the jury against me. It's poisoned jury. I can never come back from that.
Okay, time's up. I'm gonna give you a
You
little
didn't
more
let
time.
me finish,
No,
though.
I told you
There's
how much time
you
had.
interrupted me. There's one here for
Okay,
judicial
rules of decorum.
bribery.
I'm going to remove you from the courtroom for 15 minutes.
There's
Is that what
judicial
you would like?
bribery here
Okay.
going on.
One more warning, and then you will be removed. Because that, I haven't even kept count.
You didn't
because
let me finish my motion.
I cannot tolerate your disruptive behavior anymore.
Well.
I've made this sufficiently clear before we started and shortly after we started. Okay. Now I gave you enough time,
Didn't
and
let
now
me finish.
okay. Let's remove Mr. Olson, and we're going to
DA
continue.
Sadowski is bribing the judge, and
All right, Mr. Olson.
this needs to be investigated by the FBI. Is my motion going to be submitted on the record?
We're outside the presence of the jury and outside the presence of Mr. Olson. It's 10:13. We're going to take about 10-15 minute break to give Mr. Olson an opportunity to cool down. We'll bring him back. I'll hear a state's response, and then I'm going to make a decision, and we'll see what happens at that point.
May I make a request too, just in general for planning purposes, that we limit the time for our closing arguments if you
I
think
have planned that. It will be 5
Fantastic.
minutes each
I-
for closing arguments.
15. We had
Well, you
5
get the
minutes.
last word, so I was going to, I suppose 5 might be a little too short. Okay.
I'm just saying, like,
If we did
like,
15, 10, 15, 5. You both get 15, but you get the last word. 10, 15, 5.
20. I promise I'll be very succinct.
Okay.
20, 20, 25.
25.
Or, I mean,
20.
15, 25.
Okay.
Happy with that. Thank you for
Okay.
compromising.
Okay, we're off the record. outside.
love
The,
the
oh, I'm
outfit,
sorry.
man.
We can't. Okay. We're back on the record outside the presence of the jury. With same appearances before with state and standby counsel as well as Mr. Olson. We've now reached the jury instruction conference and preparation of the verdict forms. I've already days ago provided a draft, and again, the emphasis then was that it was a draft of the jury instructions. With respect to the jury instructions, I don't recall exactly what I gave the two of you, but it has not changed significantly. They are the following jury instruction numbers. I'll read off the numbers. Okay. Oh, I'm sorry. I said we were going to come back and then allow state to respond to Mr. Olson's motion for mistrial. Is that why you're looking at me, state?
No, I didn't grab my stack of draft jury instructions, and so
let's go off the record for me to print the final draft that I prepared for both parties, and then let's go off the record to do that because the printer is quite loud, so Bill can't hear me or the parties, even if you're given the opportunity to respond to the defense's motion for mistrial.
Your Honor, really
Mr.
quick,
Olson,
please.
I acknowledge that I see your hand up, but I'm not going to address you right now. We're going to go off the record.
I just
Off
want,
the record. I believe the printing is finished. So state as to your response to defense's motion for mistrial.
There isn't any real new information that I was hearing from defense, except for the fact that he can't decide whether or not he had access to the law library last night, because either he had access and they showed him it was password protected, or he didn't because he's, in the hole and he doesn't have access to anything. So besides his inconsistent statements, I think that there's nothing new, and I'd ask that it be denied.
Okay, there is nothing new, and thus the court has already decided this motion previously, and thus, yet again, the court is going to deny the motion for mistrial.
Objection.
Now
There are new items on there, Your Honor.
Do not talk. Do not talk.
Can you
Okay?
please
The court
submit?
has made a ruling. You may not like it, but you must accept it, and we move on. You can appeal it if you don't like it. Okay, no, moving on to
Can we just place it on the
jury
record, Your Honor?
instruction. Your objection is noted on the record.
I just want to put it on the record and CCAP the motion.
Oh, the written motion.
Yes.
Yes, I will direct Mr. Clerk to accept that and file it as part of the file. Yes, that's permissible. Okay, now state and Mr. Olson, as to the jury instructions, you both should have in front of you, and I apologize, but I did not print 3 sets. So defense at defense table, Attorney Wasilewski and Mr. Olson, you'll have to look at the same set. But everyone should have a set of the final jury instructions. And now that you have the printed jury instructions in front of you, I'm not going to read off into the record the jury instruction numbers. Effectively, in terms of the substantive jury instructions, they remain the same as what I read in the preliminary instructions. Of note is 1281. Given the enhancer, I added, I believe, 997. I also, although the state did indicate that I read the correct addresses, if the parties can just confirm that it's consistent with the evidence, which I believe it is, but you never know, mistakes can happen. And with respect to circumstantial evidence, given all the evidence that's come in, jury instruction 170, 172, 173 are appropriate. And then the other jury instructions are the usual. Lastly, I do want to point out that I'm limiting the parties in their closing arguments, which the court can do. In indicating so, the state has requested that the parties be given more time. The parties are given equal time. It's just that the state has the last word, so they go first. Their time is broken up, divided between the fact that they go first and they have the last word. So in this case, the state will have 15 minutes. Mr. Olson has 20 minutes, and then the state has the last word with 5 minutes. I will start the timer when you start speaking, when you start your closing arguments. It's going to be a hard stop, and I apologize in advance to the court reporter. The alarm's going to go off, and when it goes off, that means you're done. Okay, that's the best way that I can think of to make sure that we're keeping track. All right, I'm going to also, I just realized now that in jury instruction 484, I need to reprint page 27 because I neglected to include in there, in my reading of the jury verdict form to the jury, that if you find the defendant guilty of kidnapping, you must answer the following questions. So with the exception of that, everything should be correct. Okay, let's go off the record. Let me print this, and then I'm going to circulate the binder. And my process is that the finalized jury instructions and finalized verdict forms are contained in this green folder, which will go back to the jury. The state will review it first, and then defense will review the binder. And on the record, I will ask each of you to confirm that you don't have any issues with what I put together. And then we bring the jury in for my reading. State?
Two things, Your Honor. Count 2 also has the enhancer.
Okay, give me a minute. Yes, that is correct. So,
and then additionally, I don't see jury instruction 140, burden of proof, which is fairly standard for closing instructions. I know Your Honor read it in the preliminary instructions.
that is correct. Okay, give me a minute. 140 and enhancer. Let me make those corrections first. Okay, back on the record. State, anything else?
No, thank you.
And then defense, relative to the jury instructions and verdict forms, which, again, is in the printed version you have.
Yes, my first objection is that the burglary, especially for count 4, again, someone watching the house is not the owner, does not consent ownership or the damaged party. So I think, I don't know if that's noted. Is this one right here? It has to be person in lawful possession of the home. If I'm watching someone's home, that does not give me lawful possession of their home. So I don't see how that wasn't dismissed, Your Honor, but for
I have a couple of more or less. I have a couple of just more or less editing things on page 9. There in the first paragraph there is a his/her option, and I imagine you want to just. It's in 2 places in that first opening paragraph, and since the pronoun refers to the alleged victim, it would be a her.
Okay, that's changed.
And then on page page 20, in the opening paragraph, it refers to intentionally entering the building, but under the elements, you've entered the phrase motorized type of home, so there's that inconsistency there.
On page 20?
On page 20,
element 1?
the first paragraph of the burglaries instruction defining crime, it's committed by one who enters a building, but then in the elements, this concerns the RV, so you filled in motorized type of home under the elements, but not in the opening paragraph.
I see it too, Your Honor. It's right
That relates to count 4. It's count 5, which would be on page 20. You know what? I made some changes, so maybe our pages aren't syncing up. So the 1421, as relates to count 5.
yes.
At the opening paragraph where it says enters a building, it should be, instead of building, a motorized type of home. Okay.
Those are it for corrections that I spotted.
Okay. Motorized type of home in the opening paragraph of the definition, and then what else? Was that it? Was that the only place?
Well, you said you already corrected the other one about the gender in the kidnapping
Yes.
victim, so that's it.
All right, so then I'm going to circle back to you, Mr. Olson. The reason why I just went ahead and put in the changes that were recommended by Attorney Wesley is because they were easier to do and didn't require a whole lot of discussion. Are you asking the court effectively to put in the legal definition of lawful possession?
No, I'm stating that I'm curious as to why it wasn't dismissed by Your Honor, since clearly someone watching the home is not legal, is not the lawful owner. But go ahead.
We're beyond that stage. I'm
right.
asking about jury instructions.
So
anything else relative to the jury instructions and verdict form? Okay, hearing nothing more, I'm going to now print. We're going to go off the record so I can print the finalized jury instructions off the record. outside the presence of the jury. I have updated count 1, the guilty verdict form, to include a yes/no line under the question of did the defendant commit the crime of kidnapping against a person who was 60 years of age or older, and that should have been corrected. And also count 2, the guilty verdict form, will also have that same yes/no. Okay, aside from that change that I did while parties were reviewing, do the jury instructions and verdict forms meet with your approval?
Yes.
And defense, do they meet with your approval? Mr. Olson? Or actually, Attorney Wesleski, you've had an opportunity to also view and go over everything. We're beyond arguments for substantive changes. Does the binder containing the jury instructions verdict forms meet with, or is consistent, not that it meets with your approval, because I don't think technically you get to approve this, but is it consistent with what was discussed in the record and the changes the court indicated the court would make?
I frankly didn't review it. Mr. Olson was monopolizing my attention. I'm sorry.
Okay, all right then. Mr. Olson, you had a chance to review it.
I was asking him to assist
Enough.
me. Can
Off
you
the
give me a
record.
minute
No,
with
off the record,
to
and then
review it?
I'm going to give the binder back to defense table. Attorney Wesleski, take a look at it because I'll ask you the same question so that I can get a response on the record. Ultimately, the court has discretion deciding what to use and ensuring that the verdict forms are consistent with the jury instruction the court reads. Off the record. Mr. Olson, I'm reminding you that once the court makes a decision, you are to accept it and move on. I'm also reminding you that you'll be allocated 20 minutes for your closing arguments. Once the timer goes off, you are to stop talking immediately and do not argue with the court. Do not continue talking. I want to make sure that you are advised of that or given notice of that again. We're off the record. Attorney Wasilewski, to assist the court in moving this case forward, given the court's discussion with the parties during the jury instruction conference and verdict forms as to what the finalized jury instructions are and the verdict forms, are they consistent with ultimately what the court decided and the changes the court indicated the court would make?
Yes.
Okay, and let's move forward. Let's bring in the jury. I'm going to now read the final jury instructions for you. There is this green binder that will go back to the jury room for your use during jury deliberations. The verdict forms are also in there. While you will have that printed version of the jury instructions, I still ask that you please pay close attention to what I'm reading. It's quite lengthy, so please be patient. Also, the parties will have an opportunity to address you, and please pay attention to them as well. Just so I don't surprise anyone or startle you, I did instruct the parties that I am limiting their closing arguments, and I have the timer ready, and when it goes off, it might be a loud beep, and don't be startled if that's the timer. Okay. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the laws given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. And determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing, for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all their facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. And information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. The first count of the information in this case charges that on or about November 23, 2022 at 3137 West Rawson Avenue in the city of Franklin, Milwaukee County, Wisconsin, that the defendant by threat of imminent force did confine BAH without her consent and with intent to cause her to be secretly confined. To this charge, the defendant entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Kidnapping is defined in 943-31-1B of the Criminal Code of Wisconsin is committed by one who, by force or threat of imminent force, seizes or confines another person without consent and with intent to cause her to be secretly confined or imprisoned or to be carried out of the state or to be held to service against her will. Before it may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. 1. The defendant confined BAH. 2. The defendant confined BAH without her consent. 3. The defendant confined BAH forcibly. 4. The defendant confined BAH with intent that BAH be secretly confined. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Although this requires genuine restraint or confinement, it does not require that it be in a jail or prison. If the defendant deprived BAH of freedom of movement or compelled her to remain where she did not wish to remain, then BAH was confined or restrained. The use of physical force is not required. One may be confined or restrained by acts or words or both. A person is not confined or restrained if she knew she could have avoided by taking reasonable action. A reasonable opportunity to escape does not change confinement or restraint that has occurred. Without consent, as used here, means that there was no consent in fact, or that consent was given by a BAH because of her fear caused by the defendant's use or threat of imminent use of physical violence on BAH. Forcibly means that the defendant actually used force or threatened the use of imminent force to overcome or to prevent BAH's resistance to being confined. Imminent means near, at hand, or on the point of happening. If you are satisfied beyond a reasonable doubt that all four elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. The information alleges that not only that the defendant committed the crime of kidnapping, but also that the defendant committed that crime against an elder person. Elder person means any individual who is 60 years of age or older. If you find the defendant guilty of kidnapping, you must answer the following question. Did the defendant commit the crime of kidnapping against a person who was 60 years of age or older? Knowledge of the victim's age is not required. A mistake about the victim's age is not a defense. If you're satisfied beyond a reasonable doubt that the defendant committed the crime of kidnapping against a person who was 60 years of age or older, you should answer the question yes. If you're not so satisfied, you must answer the question no. The second count of the information charge is that on or about November 24, 2022, at 3233 South 27th Street in the city of Milwaukee, Milwaukee County, Wisconsin, that the defendant did intentionally possess with intent to use personal identifying information of BAH to obtain anything of value without the prior authorization of that person. To this charge, the defendant also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 9432012 of the Criminal Code of Wisconsin is committed by, is violated by one who intentionally uses, attempts to use, or possesses with intent to use any personal identifying information or personal identification document of an individual, including a deceased individual, to obtain credit, money, goods, services, employment, or anything else of value or benefit without the authorization or consent of the individual, and by representing that he is acting with the authorization or consent of the individual. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. 1. The defendant intentionally used or attempted to use or possessed with intent to use personal identifying information or a personal identification document of BAH. Personal identification document means a document containing physical, personal identifying information, an individual's card or plate that can be used to obtain money, goods, services, or any other thing of value or benefit to initiate a transfer of funds. Any device that is unique to, assigned to, or belongs to an individual and is intended to be used to access services, funds, or benefits of any kind to which the individual is entitled. 2. The defendant intentionally used or attempted to use or possessed with intent to use personal identifying information or a personal identification document of BAH to obtain credit, money, goods, services, employment, or anything else of value or benefit. 3. The defendant acted without the authorization or consent of BAH and knew that BAH did not give authorization or consent. 4. The defendant intentionally represented that he was acting with the authorization or consent of BAH or the information or document belonged to him. Intentionally requires that the defendant had the mental purpose to obtain credit, money, goods, services, employment, or anything else of value or benefit by using personal identifying information or a personal identification document of BAH without BAH's consent or authorization. If you're satisfied beyond a reasonable doubt that all four elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. The information alleges that not only that the defendant committed the crime of unauthorized use of an individual's personal identifying information or documents, but also that the defendant committed that crime against an elder person. Elder person means any individual who is 60 years of age. If you find the defendant committed, if you find the defendant guilty of unauthorized use of an individual's personal identifying information or documents against a person who was 60 years of age or older, let me reread this. The information alleges that not only did the defendant commit the crime of unauthorized use of an individual's personal identifying information or documents, but also that the defendant committed that crime against an elder person. Elder person means any individual who is 60 years of age or older. If you find the defendant guilty of unauthorized use of an individual's personal identifying information or documents, you must answer the following question. Did the defendant commit the crime of unauthorized use of an individual's personal identifying information or documents against a person who was 60 years of age or older? Knowledge of the victim's age is not required, and mistake about the victim's age is not a defense. If you're satisfied beyond a reasonable doubt that the defendant committed the crime of unauthorized use of an individual's personal identifying information or documents against a person who was 60 years of age or older, you should answer the question yes. If you're not so satisfied, you must answer the question no. The third count of the information charges that on or about November 29, 2022 at 3530 West Rawson Avenue in the city of Franklin, Milwaukee County, Wisconsin, that the defendant did knowingly obstruct an officer while such officer was doing an act in an official capacity and with lawful authority. To this charge, the defendants entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Obstruct an officer as defined in 94641 of the Criminal Code of Wisconsin is committed by one who knowingly obstructs an officer while the officer is doing an act in an official capacity and with lawful authority. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. 1. The defendant obstructed an officer. To obstruct an officer means that the conduct of the defendant prevents or makes more difficult the performance of the officer's duties. 2. The officer was doing an act in an official capacity. Officers act in an official capacity when they perform duties that they are employed to perform. 3. The officer was acting with lawful authority. Officers act with lawful authority if their acts are conducted in accordance with the law. 4. The defendant knew that the officer was an officer acting in an official capacity and with lawful authority, and that the defendant knew his conduct would obstruct the officer. You cannot look into a person's mind to find knowledge. Knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. If you are satisfied beyond a reasonable doubt that all four elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. The fourth count of information charges that beginning November 28, 2022 and ending November 29, 2022 at 7251 South 35th Street in the city of Franklin, Milwaukee County, Wisconsin, that the defendant did intentionally enter a building without the consent of the person in lawful possession of the place and with intent to steal. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Burglary as defined in 943-10-1M of the Criminal Code of Wisconsin is committed by one who intentionally enters a building without the consent of the person in lawful possession and with intent to steal. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. 1. The defendant intentionally entered a building. 2. The defendant entered the building without the consent of the person in lawful possession. 3. The defendant knew that the entry was without consent. 4. The defendant entered the building with intent to steal. Intent to steal requires that the defendant had the mental purpose to take and carry away movable property of another without consent, and that the defendant intended to deprive the owner permanently of possession of the property. The intent to steal must be formed before entry is made. The intent to steal, which is an essential element of burglary, is no more or less than the mental purpose to steal formed at any time before the entry, which continued to exist at the time of the entry. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you're satisfied beyond a reasonable doubt that all four elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. The fifth count of information charges that on or about November 19, 2022 and ending November 29, 2022 at 7271 South 35th Street in the city of Franklin, Milwaukee County, Wisconsin, that the defendant did intentionally enter a motorized type of home without consent of the person in lawful possession of the motorized type of home and with intent to steal whether or not any person was living in such home. To this charge, the defendant entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Burglary as defined in 943-10-1M of the Criminal Code of Wisconsin is committed by one who intentionally enters a motorized type of home without the consent of the person in lawful possession and with intent to steal. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. 1. The defendant intentionally entered a motorized type of home, whether or not any person is living in such home. 2. The defendant entered the motorized type of home without consent of the person in lawful possession. 3. The defendant knew that the entry was without consent. 4. The defendant entered the motorized type of home with intent to steal. Intent to steal requires that the defendant had the mental purpose to take and carry away movable property of another without consent, and that the defendant intended to deprive the owner permanently of possession of the property. The intent to steal must be formed before entry is made. The intent to steal, which is an essential element of burglary, is no more or less than the mental purpose to steal formed at any time before the entry, which continued to exist at the time of entry. You can now look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in the case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all four elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless, in your deliberations, you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An exhibit becomes evidence only when received by the court. An exhibit marked for identification not received is not evidence. An exhibit is in evidence whether or not it goes to the jury room. Relative to exhibits, if there's an exhibit that the jury would like to see, pass a note to the deputy. He'll let me know by way of your note, and then if it's an exhibit that can be given to you in the jury room after I consult with the parties, I may send it back. If it's an exhibit that requires viewing, you'll be brought out into the courtroom here to view it. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before it may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether the consciousness of guilt shows actual guilt are matters exclusively for you to decide. Evidence has been presented that the defendant possessed recently stolen property. Whether the evidence shows that the defendant knew the property had been stolen or participated in some way in the taking of the property is exclusively for you to decide. Consider the time and circumstances of the possession in determining the weight you give to this evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence, under the instructions given to you by the court. Okay, I understand that the deputies already collected your notebooks. At this time, I'll call state to make your closing argument.
Your Honor, I had asked the deputy, I need to use the restroom really bad. I've been holding it for quite some time.
Okay. Members of the jury, let's take a 3-minute break. I remind everyone that until we have concluded with these instructions, you are not to talk about this case and you are not to conduct your own research. Okay, 3 minutes. I did note that I need to update jury instruction 14 to correctly reference the charge of unauthorized use of an individual's personal identifying information or documents. That is how I read it, but the printed version does not have that, so I'll make that change. Other than that, the jury instruction by remains the same as before. Okay, Mr. Olson, Us in the courtroom. Once he's situated, let's bring in the jury.
Your Honor, I have another motion to enter on the record.
We're off the record until the jury comes in, and you're not allowed to make a motion at this time. We are closing. The next time you can make a motion is after closing and after the jury has been taken to the jury room for deliberation. Another outburst from you will be a violation. I've already informed you as to court procedure.
I just need the record to reflect the object not being able to
Olson, you need to
testify
stop
to 4
talking.
counts.
I'm going to turn off microphones at defense table until it's time for Mr. Olson to make his closing arguments. Okay, bring in the jury.
I can't see when they come in on the monitor. I'm just gonna keep it.
Yeah.
Because
Fair enough.
Bill, you ready? We're outside the presence of the jury. I'm giving you notice, and it's not to elicit a response for you, Mr. Olson, but I'm giving you notice. If you continue to be disruptive and refuse to follow the court's orders and instructions for you to be quiet when you're supposed to be quiet, I will have you removed and you will lose the opportunity to make closing arguments. Okay, now we're off the record while we wait.
Your Honor, I assume we're going past noon.
Yes.
Okay, thank you.
I did send a message to the chief. I don't know he's reading it, but we are not leaving.
Understood.
Record. Okay, state as to your closing argument.
Thank you. Ladies and gentlemen, I believe I started my opening statements this way by thanking you for your patience in advance. And I renew that thanks now as we are here on a Saturday. I truly appreciate all of you paying attention and being patient through these processes. What a closing argument is just that, an argument. What I get to do now is summarize the events as they occurred, as the testimony showed, but in a way to draw it all together. Because again, this trial started on Tuesday. We didn't get to too many witnesses on Tuesday, but here we are on Saturday. One caveat, just like I gave at my opening statement, if you remember something differently, you are to go off of your recollection and your notes. You all had notepads again. They're taken away during arguments because what I say is not evidence. Again, if the law that I say is also not the same as what the judge read, the judge is going to give you a binder at the end of this. So you can refer back through anything. There's a lot of tools and tricks in there to figure out how to go through this process. So you get that entire binder at the close of evidence in order to start your deliberation. So I always like to put the ground rules on first. And then now let's talk about the state of Wisconsin versus Timothy Olson. Ladies and gentlemen, this was Betty Hanel's worst day of her life. You heard her say that on the stand. You heard her talk about what happened. She talked about how it now appears in her nightmares almost every night and why she's able to remember what happened in pretty good clarity, considering it's been 3.5 years and she is 82 years old. She talked through the details of what went on when she was awake. She stated she was in and out of sleep. She stated that she was driven around the city. But let's talk about how we went through and corroborated what Ms. Hanel said, right? First, you heard from Michael Four. Michael Four testified. He was in custody. He admitted that. And he said he saw Betty waving from her car. He stopped and talked to Betty, where she was talking about how she was kidnapped, how she was held at gunpoint. She went through that process with Michael Four. You then heard, too, from Edwin Roman. Edwin Roman just found a phone in the street. He found a phone in the street. It wasn't broken. He got into it. It was in working order. He tried to find the owner, couldn't find the owner, and then finally the Greenfield police officers called him, specifically police officer Garrett Olson. Garrett Olson was one of the initial responding officers on the scene. So back on Wednesday, we heard from Garrett Olson. He responded to Grandpa Frank's, 3033 South 108th Street, talked to Michael Four, found the phone from Edward Roman, and everyone at this point was just trying to figure out what would happen. Again, some age bias with these officers. I think that was pretty apparent because they are sitting there talking about how she was just a confused old lady at first, but they still investigated. They then got the Franklin officers involved who appeared on scene. Franklin officers appeared on scene. We heard from Ms. Hannell pretty early on in this trial. Ms. Hannell, one thing, she told you she was 82 years old. I don't think there's any necessarily dispute that she seemed to be an older person. She walked in here with a walker. But sharp, was able to tell you that story, was able to go through those details, had very precise language about what she heard and what she saw. The credibility instruction that judge read is one of the ones that I would like to point out. Who here has something to gain or lose? Who here had precise knowledge, at least to the extent that she was able to recall when she wasn't being potentially forced to drink liquor in a bottle? Who here, 3.5 years later, was able to talk through what happened? Think about that as you're going through all of these events. She was caring for her brother, went to Casa di Giorgio because she had a troubling time with her brother, for one glass of wine, which was her usual, and to read on that Nook book. That Nook book that was found in that back seat of that car, right? Corroboration of what she said. It wasn't just any book. She remembered the Nook book. She remembered the one glass of wine. The Chardonnay bottle. She says she only drinks Chardonnay. Chardonnay bottle found in her car unopened. Where does all this corroboration lead to? So, she goes, she sits at the bar, she talks to Mr. Adrizi, the owner of Casa di Giorgio. She talks to him briefly, some small talk. She's known him for years. She's been going there since before her husband died. And then this individual, Mr. Olson, who she picked out in court, comes up to her and sits next to her at the bar, offers to buy her a couple of drinks. She says no. It appears to Mr. Adrizi that they're having some sort of conversation. He's working, though, bartending. He talked about another person in the restaurant. Going through this, when they leave the restaurant at the same time, and again, think of the different perspective of those individuals that testify. Is this an inconsistency? Or is this Rex Adrizi was bartending and he followed her out so it looked like they left together? Think about that. You, ladies and gentlemen, get to bring your common sense and experience in the door with you. You don't have to leave that out in the hallway somewhere. You didn't have to leave it at home this morning. You as jurors talk to people every day. You determine whether or not someone is lying to you every day. You determine the believability of people every day. You get to take that back with you into that jury room and use it. Don't leave that common sense at the door. You talk about this. Ms. Hannell then states she gets into the driver's seat, and then you saw her motion, hand in the pocket, like there was a gun. She admitted she never saw a real gun. She was terrified. Absolutely terrified. Mr. Olson went from being kind and friendly to vicious. Ladies and gentlemen, one thing you also get to take into account is the demeanor of witnesses in this case. What they looked like when they testified. Their reactions to questions. Don't ignore that either. You don't just have to take words. What they looked like and how they sounded is also very important in this case. Ms. Handel talks about being made to urinate in an alley. Just to bring this up right now, I'll circle back to it later, but Mr. Olson also testified about that. Testified that she had to go right now because you know how women are. And then he also testified that, well, after she went in the alley somewhere on the north side, they then went to like maybe a Chili's or Applebee's down on the south side. So while he made her pee in an alley, excuse my inelegant language, they also then went, after that to some sort of Chili's or Applebee's on the south side. That was still open, but yet everything was closed. Just how that testimony came apart, again, ladies and gentlemen, the believability of that is for you to decide. Ms. Handel testified too that her purse was maybe taken. She didn't know. She was a little bit confused about that, but she knew her credit card was taken and she knew her ID was taken. We heard from Officer Andre Nemish. Officer Andre Nemish was the person that talked to Ms. Handel first. You saw his body cam. You got to see the demeanor of Ms. Handel at the scene. You also got to see how she was moving. Remember Mr. Olson also testifying that she could walk just fine? You saw that video. I'd also like to say this is Exhibit 102. 102, I don't know if you can all see it, but again, as the judge said, if you want it, you can ask for it in the back. Exhibit number 102 shows a lovely pink cane. So clearly she was walking fine, and that was just a decorative device left in the car, probably by Mr. Olson, right? So, ladies and gentlemen, think of all of this again. The credibility of what went together, going through all of this. You heard from Robert Handel, again, talking about the demeanor of his mom at the time, what she's like, how she's generally able to be around and lives on her own still. That's great. She knows what's going on. We discussed Mr. Adrisi a little bit, so in interest of time, I'll keep moving forward. Officer Friedbacher conducted that photo array with Mr. Adrisi, who also picked out Mr. Olson, signed that back of that photo, even though he had never seen him before in his life, was able to pick it out of that photo array. Officer Mark Hernan, heard from him. He also responded to the scene. He observed Miss Handel to be confused and sleepy, found the car keys under the front seat, and she stated to him that the drinks in there were not her own. The officers. Then when Mr. Olson saw officers a few days later, he ran. What did he run with? And I think what's important to discuss too with this is that when he ran, he had a bicycle that was taken from that garage, that building. Again, these jury instructions have a lot of legalese. That building is a garage. He also had those items from that motorized home, that RV vehicle that the Schusters testified to. The shampoo, the e-bike key, that is a motorized vehicle. So, and the personally identifying documents, card, the judge mentioned card used to buy things, credit cards. So there's a lot of legalese in these jury instructions to cover a lot of the elements. So again, make sure you read those when you get back there. But I think what we need to point out here is that he ran. He saw officers and he ran. He didn't say, Betty and I know each other. He ran. Let's go through this too. Detective Zaleski downloaded her phone. No evidence in the phone that they knew each other. Some Google voice messages that the defendant testified to, and that he talked about that while she was sleeping sometime in the middle of the night, Ms. Handel also created a Google Voice account to find out where the defendant went and try to ask him to come back. That's the testimony that was put on the stand. Ladies and gentlemen, how feasible is that? How realistic is that? One thing in the photographs that were put into evidence of everything that Mr. Olson had on his person, those deep pockets, officers talking about how things were falling out because they couldn't find everything. One thing that wasn't found on Mr. Olson was a cell phone. Going through all of this, finding the map that goes through all over the city for almost 16 hours in every inch of the city in no discernible path. Talking about the burglaries that happened in near the area where Mr. Olson was arrested, very close together. Everything here was extremely close together. And then some more corroboration. We heard from 2 crime lab analysts. Melissa Graff talked about the fingerprint. Ms. Molly, this is one of the things too that corroborates what Ms. Hannell said. She was forced to drink from those bottles. They were shoved to her mouth. It wasn't just Ms. Hannell's DNA that was found on the lips of those containers. It was also Mr. Olson's. Mixture of those 2 DNAs. Ladies and gentlemen, Mr. Olson's testimony too, he wants you to believe that they were friends. He wants you to believe they had this relationship. He said that they were there for they knew each other for a couple of years before November 2022. Ladies and gentlemen, a couple of years before 2022 was 2020. So he also wants you to believe in sometime during 2020, they met while he was an Uber driver and a nearly 80-year-old woman was just out for 2-for-1 burgers. I remember 2020. I don't know if you remember 2020, but I'm pretty sure most restaurants were closed during the majority of 2020. Think of all this. Think of everything, ladies and gentlemen. When you go back there, read the jury instructions. Go through the elements. And at that time, ladies and gentlemen, I would ask that you fill out those guilty forms. It is my burden of proof. So Mr. Olson will go next. And then I will have a chance to get up here one more time. So I thank you again for all of your patience, and I appreciate your time. Thank you. Okay, Mr. Olson, now is your time.
Okay, hold on.
And your clock has started.
1 second, please. My closing argument is in my paperwork that has been disheveled. It's in the back with the rest of my documents.
Clock is starting.
Oh my God. Where's that? So, as I stated, I never denied knowing Betty Hannell or being with her. So all of the evidence found that places me in the car is irrelevant. As Rex stated, and I thought he testified pretty well, even though I was trying to pay attention. I was a little incoherent at the time from some other issues. But anyway, I did hear Rex, and Attorney Wazalewski informed me of some of his testimony that he did testify quite well on my behalf as well. As he stated, we left together, and we spoke. Me and Betty spoke for almost an hour at the bar, unlike what she had claimed, just for a minute or two. And to rebut what the DA said, sometime within the 2 years before 2022, it wasn't during the time that she claimed when COVID, where everything was closed. But there is a place that Betty goes to. She's the one that, when I arrived there, told me about the buy one, get one burger. I thought that was funny, because you buy it.
Actually, not in evidence.
Okay. Sustained.
I did.
Was not in evidence. Continue with your closing.
So, as I had stated in my testimony, I talked about meeting Betty at this restaurant bar. as I had stated, Rex clearly noticed my demeanor at the restaurant and that I was well dressed and well mannered. I'm never a vicious or violent person. Anyone that knows me knows that. We left together, like I said earlier yesterday. When I walked out, I was going to go get into the passenger seat, but her door flew open all the way and she couldn't shut it, so I went and shut it for her. So if there was a camera outside, this wouldn't even be here right now. As a detective testified, he didn't even bother to investigate camera footage in such a serious allegation. I mean, there's no footage of anything that would resemble a kidnapping. I asked the detective if he would turn over his version of the phone download so I could have it investigated even by the FBI. Why wouldn't that have happened if there was nothing to hide?
Objection. I'd ask that last sentence be struck.
Well, to the extent it's closing, I'm going to just allow it. Let's continue.
I also asked for all the photos that he had to be turned over of the car so that, because there was one missing, he denied to do that. Why? This is very odd. In such a serious investigation. My interrogation was not used, which, if anybody watches like 48 hours, that's pretty rare.
Action, not in evidence.
Sustain. Continue.
The detective perjured himself on the stand numerous times.
Objection, relevance.
To the extent that this is closing, I'll allow it, but continue.
Am I going to get more time for these objections?
Continue, please.
As I said before, the detective didn't thoroughly investigate this for a reason, because he knew as well there was no crime committed. There was more evidence that this was not a crime. As I testified, me and Betty went to several locations, and I even went into stores on her request to get things, fill up gas in her car. She gave me a birthday card, a Thanksgiving Day card. She gave me some money when I first entered the car. I knew many things about her personal life because she shared that with me over time. And as far as using the bathroom, like I said, that I testified to, the gas stations in those areas don't have bathrooms that are open to the public usually. So she couldn't wait to go anywhere else, and that was all that was. It was very odd to me as well, but and I really need to stress about requesting the original phone download from the detective, because as I stated before, that the Google Voice, and there was text from Betty to me asking me where I was and if I was coming back. And I've stated that from day 2. I called the media.
Objection, not in evidence.
Well, continue,
What?
finish.
I called the media and let them know about this text and my innocence on day 2. Channel 12, and another reporter.
Now the objection is sustained.
All right,
That was not in
okay.
evidence. Continue.
There's no evidence of any that I physically restrained anyone, and there was no, so I know in here it states, that the, where's it? Oh, just because there's a reasonable opportunity to escape doesn't change confinement. There was nothing to escape from. I mean, I'm not a violent person, and I would never mistreat an elderly person that way. I'm very close with my family, my mother, who is, you know, elderly as well, and that's just absurd that that I would be charged with something like this. I spent many time talking with Betty about my son, grandchildren. This is a very serious charge, and I would hope that you would all look at everything and know that I'm not the one lying. There's things that were lied about, and I've tried to get this out for quite some time. I would also just like to state that you all can make your own decisions regardless of what these court rules are or any other rules they put in front of you, especially my right to have a fair trial, which was completely stripped of me.
Objection, Your Honor. Arguing for jury nullification.
Sustained. Do not do that, Mr. Olson.
Count 4, which is the burglary of the alleged burglary of the garage. In order for there to be a crime, in order for a crime to exist, there must be an injured party, and since the injured party was no longer with us and no longer able to be here, that one's a no-brainer. It's even though his sister came, she's not the lawful owner. It has to be the injured party.
Objection misstates the law.
Sustained. Do not misstate the law. Continue.
That is consent of the lawful possession.
No commentaries.
There also has to be an intent to steal. There's no way that anyone can look inside someone's head and say they intended to steal. So just on those grounds alone, it's just virtually impossible for a jury to decide that. As I wasn't able to testify to that, but I believe I spoke to question Detective Zalewski about this. I did know the owner of the RV, and I was in that area for quite some time.
Objection, not in evidence.
What?
So overruled. Continue, please.
I was not allowed to testify about the other counts against also violation of my right to a fair trial. So I can't discuss any of those points. Is that correct?
The court cannot give you guidance on what to say at closing arguments.
The court could take away my rights. As far as the obstruction, I believe I questioned them about that. There was no obstruction. I started to get on the ground. The officer came up behind. I've never been a violent person or one to resist like that. So he tased me in the back of my arm and while I was getting on the ground, or while I was already on the ground, which surprised me. Luckily, it didn't do too much damage, just kind of shocked me a little bit. But there was definitely no obstruction, as they told. Too bad there's no video, or else you would know that for sure. And if there was any video more, if you would have done more investigation, we wouldn't even be sitting here. I've sat in this courtroom trying to fight for my rights. I really need to emphasis on count 1 and count 2. Count 2, there's no intent of anything. Count 2 with the misappropriate use of ID. She was with me. She let me use the card. As I stated in my testimony, she gave me one of the cards to use to go inside, which was why when I got out of the car and left abruptly, I still had that card with me. We were supposed to meet up anyway later on in the day, as I had also stated in my testimony, on Thanksgiving after she met her brother at Mater's. I have to stress on count 1. This is very serious and something that I believe is just absolutely ridiculous. And there's no evidence of me forcibly restraining anyone or anything like that, because it just didn't happen. And this is why Detective Zalewski did not properly investigate this. If I was an officer and I was investigating a crime like this, I would make sure I got all the videos so I could see if this person was injured, harmed, what else was happening, to see if there was a gun, something. I mean, that really goes to show a lot. And I have to restate the text in the Google Voice. If this would have been investigated by this detective, he would find that it was Betty Handel's account, and I don't have passwords to her accounts. It's pretty easily investigated, and that's not me. It was also clear that Detective Zalewski was avoiding talking about the phone download. There's a reason for that, and the reason why I stress this is one of the reasons why I'm representing myself, is because no one would go after these texts or subpoena Betty Handel's phone records, which would have easily shown there's a text missing from the phone download. I tried getting this for almost 4 years. And
In relevance and not in evidence.
Sustained, and that's correct. Continue on.
Oh, and Betty at that time was not using her cane. She didn't bring it into the restaurant when we were in Casa de Giorgio. So it was in her car. I think I noticed it as well. But she didn't use it. She moved around quite easily. So the items that I was found with is clearly not something someone would enter somewhere to burglarize for. This is where like gold watches, or this was you're talking about like a pack of Skittles and some marbles. That's not what the items were. But I'm just saying this is ridiculous. These charges are all absurd. again, the amount of things that I knew about Betty's family and past, and I could have only known by knowing Betty. That she had power of attorney over her brother's affairs. Her sister embezzled money from her brother because he was sick of, I'm not sure what was wrong with him, but and that she had passed away and she was younger than Betty. She made that known that the sister was younger, that she had already passed away. For such a serious allegation, I'd like all of you to think about some of the things that, some of the testimony that was back and forth. I slept all night, I was up all night, or Detective Zalewski claiming that I claimed I was Wes Erdman and then recanted his statement. I'd like all of you to use your common sense as well and realize who's lying here. And I'm not even referring to any of the alleged victims. They're clearly hiding things, and you can tell from their facial expressions. I've also like all of you to know that I've contacted the FBI to investigate some of these matters, and I did state this on the record.
Not in evidence.
Correct, not in evidence. Move on. Time's up. Okay, state closing. Your last word on the closing.
Thank you. Ladies and gentlemen, just briefly. He's such a nice guy, he left a 79-year-old woman on the side of the road without her cell phone, waving for help, after an argument. But he never is angry. Ladies and gentlemen, just think of everything. Think of this case as in total. I think the one thing that Mr. Olson and I might agree upon is that this is serious. You need to make sure you look at the instructions. You need to make sure you evaluate the evidence. You need to give the time which it deserves. Go through those jury instructions. And just think of things like the jury instruction you'll also get. It's called the burden of proof. You are to search for the truth. You're not to look for doubt. You are to search for the truth. So the last line in that jury instructions. And ladies and gentlemen, just remember the evidence. Remember Mr. Olson giving a fake name at the time he was arrested. Remember Mr. Olson being arrested with that credit card of Betty. Remember all of these small little details that draw the witness's testimony together. And then I would ask that you would find him guilty of all the charges. Thank you.
Members of the jury, you are to decide this case fairly and impartially, without fear or favor, and without passion or prejudice. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdicts are matters for the court alone to decide and must not affect your deliberations. The following forms of verdict will be submitted to you concerning the charges against the defendant, Timothy Luther Olson, Jr. One reading, we the jury find the defendant, Timothy Luther Olson, Jr. guilty of kidnapping, seizes or confines forcibly as charged in count 1 of the information. If you find the defendant guilty of kidnapping, you must answer the following question. Did the defendant commit the crime of kidnapping against a person who was 60 years of age or older? Another reading, we the jury find the defendant, Timothy Luther Olson, not guilty of kidnapping as charged in count 1 of the information. Another reading, we the jury find the defendant, Timothy Luther Olson, Jr., guilty of unauthorized use of personal identifying information or documents obtained thing of value as charged in count 2 of the information. If you find the defendant guilty of unauthorized use of personal identifying information or documents, you must answer the following question. Did the defendant commit the crime of unauthorized use of personal identifying information or documents obtain thing of value against a person who was 60 years of age or older? Another reading, we, the jury, find the defendant, Timothy Luther Olson, not guilty of unauthorized use of personal identifying information or documents obtained thing of value as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Timothy Luther Olson, guilty of obstructing an officer as charged in count 3 of the information. Another reading, we, the jury, find the defendant, Timothy Luther Olson, Jr., not guilty of obstructing an officer as charged in count 3 of the information. Another verdict form reading, we, the jury, find the defendant, Timothy Luther Olson, Jr., guilty of burglary of a building or dwelling as charged in count 4 of the information. Another reading, we, the jury, find the defendant, Timothy Luther Olson, Jr., not guilty of burglary of a building or dwelling as charged in count 4 of the information. And another verdict form reading, we, the jury, find the defendant, Timothy Luther Olson, Jr., guilty of burglary, motorhome, or trailer home as charged in count 5 of the information. Another reading, we, the jury, find the defendant, Timothy Luther Olson, Jr., not guilty of burglary, motorhome, or trailer home as charged in count 5 of the information. It is for you to determine whether the defendant is guilty or not guilty of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk to the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you reach a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. Mr. Clerk will then publish the verdict, and he will poll each of you to ensure that that is in fact your verdict. At this time, Mr. Clerk is going to select 2 alternates who do not join deliberation and also swear in the deputies, the bailiffs.
Alternate juror number 1 is juror number 27. And number 30.
7, can you stand? Join the rest in deliberations. I do want to thank you both for your service. I know this was a great imposition of your time, and on behalf of Milwaukee County, State of Wisconsin, thank you for your service. Please wait, you can be seated again, and then wait until the deputies take all of the jurors back, and then thereafter you can depart at that time. If you do need documentation, reach out to jury management on Monday. Okay, thank you. Okay, deputies then.
To the deputies, do you swear that you will keep all together in some private place, that you will not permit any person to speak to them or to speak to them yourselves, except to ask whether they have agreed upon their verdict or a discharge by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict you have agreed upon? So help you God.
Okay, thank you. I will send if one of you can come back and grab the binder. Okay. Yeah. Yes, you're ready to take, please take the jurors back there. Not yet, Mr. Olson. Allow the jury to leave. Mr. Olson, you need to stop. Okay. Mr. Olson, you've been ordered by the court to stop talking. Okay, yes, you can remove him. Okay, we're on the record outside the presence of the jury. In my reading of the jury instructions, I realized that page 30 of the jury instructions for count 2, that instead of saying kidnapping, it should say unauthorized use or personal identifying information or documents. I read it correctly, but I'm going to make that change so that the printed version of the jury instruction is consistent with what I read. Okay. And then, Deputy, you can come back and take the binder for the jury. Okay. You can take Mr. Olson back there. You want to let the chief in?
So I'd be able to put my motion on the record, Your Honor, after closing arguments? My motion right there.
Yeah, much after closing argument, not immediately after. Hi, Chief. How are you?
But it was actually, so it was really nice to just be
we're on the record outside the presence of the jury. Mr. Olson, you are instructed by the court to not speak at this time because there is no need for you to place anything on the record at this time. I understand you want to file a motion. There is an opportunity for you to put in any motions you may have. That's done after the verdict, okay? So I understand there's a verdict. We'll bring in the jury. By the way, we're outside the presence of the jury. Will the presiding juror please stand? Okay. And your juror number? 11. And has the jury reached verdicts? Okay. I'll take a look at the verdict forms. And juror 11, is it correct that the jury reached unanimous verdicts in these counts? Okay, at this time, I'm going to have Mr. Clerk publish the verdicts. After he's done doing so, he will poll each of you to ensure that these are, in fact, your verdicts.
We, the jury, find the defendant, Timothy Olson Jr., guilty of kidnapping, seizures, or confinement or civility, as charged in count 1 of the information. We find the defendant guilty of kidnapping. He must answer the following question: did the defendant commit the crime of kidnapping against a person who is 60 years of age or older? The answer is yes. We, the jury, find the defendant, Timothy Olson Jr., guilty of unauthorized use of personal identifying information or documents of increased value as charged in count 2 of the information. If you find the defendant guilty of kidnapping, you must answer the following question: did the defendant commit the crime of kidnapping against a person who is 60 years of age or older? The answer is yes. We, the jury, find the defendant, Timothy Olson Jr., guilty of obstructing an officer as charged in count 3 of the information. We, the jury, find the defendant, Timothy Olson Jr., guilty of burglary of a building or dwelling as charged in
Mr. Clerk, before you poll, can I see the verdict forms again? Okay, members of the jury, with respect to the verdict that was turned in for count 2, the verdict form that was turned in as your verdict and as your unanimous verdict is a guilty verdict of the charge of unauthorized use of personal identifying information or documents obtained thing of value as charged in count 2. The subsequent question on the verdict form reads, if you find the defendant guilty of kidnapping, you must answer the following question. Did the defendant commit the crime of kidnapping against a person who was 60 years of age or older? That was a Scrivener's error relative to kidnapping versus unauthorized use of personal identifying information or documents obtained thing of value, because in the jury instructions, it correctly asked the question of whether 60 years of age or older. That is what I read in the jury instructions, and that is what is in the jury instructions, except for that now, upon hearing Mr. Clerk publish the verdict, that the subsequent question relative to the age still has the word kidnapping when it should have had the word unauthorized use of personal identifying information or documents as charged in count 2 of the information. What I'm going to do is, before we poll you, send you back to the jury room, and then I will bring you back with further instructions, okay? But that's the reason why I'm going to send you back and then bring you back. I apologize. Okay. All rise, and we'll see you in a few minutes. Could someone else bring it up? I described that as a Scrivener error because the jury instruction has the correct reference relative to the enhancer for count 2. The verdict form, however, though, does not reference the count 2 charge. And the question is, which I will hear from the parties as to your position, whether that affects the verdict that was returned. I have not inquired with the jury relative to whether that changes their decision or not. I don't know that that's necessary, but I want to first give the parties an opportunity to place your position on the record. State?
I have two thoughts, and Your Honor, I think both are equally fine. The first thought is, we know it's a Scrivener's error. You read the instructions correctly. We could just poll the juries and then move on from there. But the second thought, and what I think might be a cleaner record, is to just send both forms back with the correct language and then have them continue to deliberate on only that count. That way they fill out the correct forms and the foreperson signs it. I think that might be the safest option, but I don't think that there's any legal reason why you couldn't just pull the jury and without doing that.
I'll start first with standby counsel. To assist the court, is there anything relative to this scenario which I need to consider? Mr. Olson, I will turn to you, but as standby counsel, he's here to, I know that because I turned them off. I can see it right here. Okay. So Attorney Wazlewski, in terms of your thoughts on this?
I don't disagree with either of the suggestions of the prosecutor. I think the second one, to send the blank form back and have them redo count 2, would clear up any possible issue with the record.
Okay. Mr. Olson, your thoughts on this and your position?
Well, first I wanted to object. You only give me 20 minutes to argue 5 counts. It's 4 minutes per count. That's
Position
a little
on the verdict
ridiculous. Well, I object to all of it. I think you hurried that to legally lynch me through this process today and hurry the jury to be back so they wouldn't want to come back next week.
Okay, I'm going to turn you off. I heard your position, which is you object. What I'm going to do is, considering the totality of the circumstances, but out of extreme caution, I'm going to print out the verdict forms for count 2. And we're going to have the jury brought back. My instruction will be for them to return to deliberate on count 2 with the new forms. And that once they're ready with their final verdict on count 2, then we'll continue the same process as we did before, which is they'll be brought out and Mr. Clerk will then publish count 2. Okay. All right, let's go off the record while I make this change. All of you back to deliberate on count 2, I have in this binder new printed verdict forms for count 2. And please read and reread the jury instructions as necessary, as needed. But once you've completed your verdict on count 2, then we'll return and repeat this process relative to count 2. Thank you. 11, has the jury reach a verdict as to count 2? Okay, and was it a unanimous verdict? Okay, I'll take a look at that. Mr. Clerk?
We, the jury, find the defendant, Timothy Luther Olson Jr., guilty of unauthorized use of personal identifying information or documents, obtain things of value, as charged in count 2 of the information. If you find the defendant guilty of unauthorized use of personal identifying information or documents, obtain things of value, you must answer the following question. Did the defendant commit the crime of unauthorized use of personal identifying information or documents, obtain thing of value, against a person who was 60 years of age or older? The answer is yes.
Thank you. Now you can poll the jurors.
Juror number 1, were these and are these your verdicts? Juror number 2, were these and are these your verdicts? Juror number 3, were these and are these your verdicts? Juror number 7, were these and are these your verdicts? Juror number 8, were these and are these your verdicts? Juror number 11, were these and are these your verdicts? Juror number 12, were these and are these your verdicts? Juror number 19, were these and are these your verdicts? Juror number 20, were these and are these your verdicts? Juror number 21, were these and are these your verdicts? Juror number 22, were these and are these your verdicts? And juror number 26, were these and are these your verdicts? Thank you.
All right, members of the jury, your service is now complete in this case. You do not have to answer anyone's questions except for the court. I know that this was an imposition of time with this Saturday trial. So I do ask that if you do have time, that you wait for me. I'd like to come and talk to you. If you don't have time, I understand you're free to go. But as I stated before, and I want to emphasize again, that on behalf of Milwaukee County, the state of Wisconsin, thank you for your service. At this time, you are discharged of any further obligation in this case. And so if you have anything in the room, you can go back and retrieve it. Again, if you have time, please wait for me. If you don't and you have to leave, that is perfectly fine. Any questions for the court at this time? Okay, juror number? You do not have to talk to anyone. You don't have to answer anyone's questions. And if anyone has any concerns about safely leaving the courthouse, I can talk to the deputies to make sure that you're able to safely leave. And so, if you, actually, why don't you guys wait for me? I'll come back there and give you some further guidance on how you can safely leave, and then also touch base with the deputies. All right, thank you for your service. Okay, we're outside the presence of the jury. I will entertain any motions after verdict when I return. I do ask for everyone to just be a little more patient with me as I go and meet with the jurors, and then I'll return. At that time, Mr. Olson, you do have, I had Mr. Clerk count your motion, 15-page single-sided motion. Unfortunately, because this isn't our usual courtroom, he doesn't have his stamp. And so that's why it's not been scanned in. But when I come back, we will address motions after verdict, as well as the motion as to procedurally what we're going to do with your motion, so that it's addressed. Okay, we're off the record. I'll be back in just a minute. Okay, Brad.
Yes.
I don't want it. Okay. I'll be right back, everyone. let's, where's Attorney Wesley? Let's just finish the motions after verdict, and then we can come back on Monday. That's true, depending on the weather. Do you have Wesley's contact to message him or call him? Back on the record. Okay, at this time, motions after verdict.
Thank you, Your Honor. The state moves for judgments based on the verdict, so guilty for all 5 counts, plus the enhancer for counts 1 and 2.
Response, if any?
My mic.
It's turned on.
I motion and demand for dismissal based on numerous grounds of misconduct, and I was not allowed to object even, which I know that ruins my rights to appeal, because you stop me from objecting at every turn. I don't know why you would do that.
All right, state's
no,
motion.
my motion, I'm entering a motion to dismiss.
Let me decide state's motion, okay? And, all right, well, you have a motion to dismiss?
Well,
what's your motion? This is motions after verdict. In other words, what do you want me to do with the verdict?
well, I'd like you to dismiss it and call it a mistrial. There was juror misconduct. Your deputies were discussing my case. You and DA Sadowski were discussing the case on your phone and text during the middle of trial. I've been told by this by numerous, and I heard things, and I heard DA Sadowski talking about it, and your phones should be analyzed for those discussions. As soon as you go back in your chambers, you and her would be texting or calling each other, planning on how you're going to forward this case and keep us here Saturday, and not stop me from testifying early so that you could do this.
Mr. Olson, you need to wrap it up on your basis.
Well, I was not allowed to testify. My rights were violated. You gave me 4 minutes to argue each count. I mean, that's ridiculous. You violated all of my constitutional rights. You colluded with my attorney off the record to appoint him. You've colluded with DA Sadowski. And I've also been informed that DA Sadowski has bribed you to keep misconduct concealed, especially my past relationship with DA Sadowski, and the texts that they withheld, and this unredacted phone download that no one will acknowledge, and there's paperwork right there.
You're going way beyond the scope of what a reasonable response would be related to motions after verdict, but specifically the state's motion. State's motion is granted in the court will order entry of judgment and conviction consistent with the verdicts. Okay, I know this is a great imposition on everyone's time, and I truly appreciate all of you being here so that we can complete this. Off the record, the state did ask if we could continue this to a later date, and I indicated at a minimum I wanted to entertain any motions after verdict before we can continue. Being that there's now entry of judgment conviction relative to these counts, we do need to set this case for sentencing, as well as any appropriate motions and when I say that, I really mean, Mr. Olson, you said that you have that motion, which I indicated was the 15-page single-sided motion. And at this point, because we're not in our usual courtroom, Mr. Clerk does not have the file stamp, but treating this just like when the clerk's office receives a motion and they wait until the next business day to officially pull it into the file, that's what I'm going to instruct him to do.
You said you would let me put this other motion in after jury instructions, and you never did. It's been sitting here, and it's about you not allowing me to testify, and I wrote this up after you didn't allow me to continue to testify on my own behalf. So you told me I could put this in, and then you changed your whole.
Okay. Mr. Olson, I think it's important for me to note for the record and clarify that I said afterwards you may do it. I more than once told you that it is not immediately after the way you wish it to be, but that after that next milestone you would be able to do so. And when it comes to filing, you may file your motions. It doesn't mean that the court will entertain it. Okay, so if you have two motions, make sure that Mr. Clerk has it, and the next business day he will then pull it into the file. The first one I want to confirm with you is the 15-page single-sided motion. Is it correct that it's 15 pages? Because I don't want you to allege later on that the entire motion was not properly filed.
Can I just quickly look at it? I believe the actual motion is 10 pages, and I've included letters that I sent.
Okay, so we're gonna go off the record for just 2 minutes. Okay, this is a great imposition in everyone's time on a Saturday, but to ensure that nothing gets lost, we're gonna go off the record for 2 minutes so that you can verify the two motions that you've indicated you want filed in this case. And again, I remind you that yes, you may file your motions with the court. It doesn't require that the court entertain every single motion filed with the court. We're off the record. It's now 1:43.
Can you give him this one, please? This is just 2 pages.
Yeah, it's two separate things. I'll take it.
Please double check the second motion as well. How many pages? And I'm going to ask you to confirm.
Are we
that.
on the record?
No, not
Oh,
yet. I'm just
all right.
I'm giving you instructions right now.
Yeah.
Okay, back on the record, Mr. Olson, as to your first motion, how many pages?
It's 15. I just wanted to clarify.
Okay, hold on. 15 page, and it is single-sided, correct?
Yes.
Okay.
10
Now,
page.
just tell me the title of that motion.
Well, the title is quite lengthy. It's mainly
I guess let me ask you differently. What are you asking from the court on that 15-page single-sided motion?
motioning the court to dismiss and for a mistrial for numerous grounds of misconduct,
Okay,
including.
then stop right there. Motion to dismiss and for mistrial.
Part of it was for investigating your deputy's phones, the jurors' phones.
Okay, hold on. I don't need to know the basis. I'm just trying to get this down so that we have a good record, so that on Monday, when we're back in business, Mr. Clerk is properly filing everything that you wanted filed, okay? That's all we're taking care of right now. As to the second motion, how many pages?
It's only 2.
Okay, and what are you asking of the court?
Also motioning to dismiss and
Thank
for
you, that's
mistrial.
That's all.
And for a mistrial.
Okay, dismiss and mistrial.
And that one's on constitutional grounds of not allowing me to testify.
Okay.
So how is this supposed to be investigated
Hold on,
when
Mr. Olson, stop. I'm gonna turn off the microphone. State real briefly as to those two motions. Not, I'm talking about procedure, and whatnot, not necessarily the substance of it, because, Mr. Olson has not, was not given an opportunity to explain on the record, and also I have not read it, but, this is where I'm going with this. Procedure was followed. At certain milestones, the parties were given opportunities to make their motions, and we've since passed those milestones. Now, before you say anything, Mr. Olson, I did tell you that you can file your motions after certain points, and I made it clear that you cannot file it immediately, but that I will give you the opportunity to do so. I now understand that your motions are motions to dismiss and for motion for mistrial, which you already had the opportunities to do so on the record when we reached those milestones. So that's noted for the record, and that's where I'm going with all of this. But I want to give the state an opportunity to respond relative to procedure, because again, the motions have not been officially filed, although they've been received by the clerk, and also because no one has had a chance to read it.
We had the opportunity to argue that. We specifically went over this at the close of all evidence of both cases, any grounds for dismissal and any grounds for mistrial. So they're not timely filed. That being said, I don't really know what they are, as I only know the rough titles. But either way, there's no urgency anymore in addressing these matters. So I think in an abundance of caution, it's probably best to file and review them, because at times Mr. Olson isn't very precise about what he calls things. So him naming a 2-sentence title is, I worry about that. And two, it's not timely, so there's no urgency. So I don't think it needs to be heard immediately as well.
So,
I'm going to now turn to Attorney Wesluski in assisting the court in understanding the options here relative to procedure.
Mr. I guess since we are after the conviction stage, although Mr. Olson can't appeal yet, I mean, I think the court has the discretion to entertain them or to, and then either grant or deny them on the merits. I think the court would probably also not be out of line at all, denying them without prejudice on the grounds that these are all issues that at this point can be raised post-conviction.
Come on now, no. So why are you having him
right,
speak on my behalf?
Mr. Olson, I'm going to turn off your microphone. All right. For purposes of scheduling, Mr. Clerk now has the two motions, and we'll set the case for motion hearing / sentencing. I'm being very optimistic relative to sentencing, but I'd like this to come back sooner rather than later. And when I say that, I'm really looking at Monday, if court is open. If not, Tuesday. Maybe perhaps it's just better to do it Tuesday.
Yeah, I would not be able to do sentencing on Monday because I don't have the ability to get the victim's notification right now.
Sure.
So Tuesday, sentencing, that would be difficult considering the factors.
Okay. Tuesday, then let's see what we have, and we'll have to squeeze this in. No, not right now, Mr. Olson. We're looking for dates.
Tuesday, Judge, right?
Yes.
Yeah, then we can do the
Tuesday.
17th at 8:30, 1:30.
8:30 is better for this date, but 1:30 is fine.
We only have statuses and schedulings at either time. There's a few at 8:30. There's only one at 1:30.
We do plan to be in trial, though, so I think if we do, that's fine. If we do 8:30, I can have the jury report later on Tuesday, and state's witness can report later. So Tuesday, March 17th at 8:30. Is that correct, Mr. Clerk?
Yes. So we'll set that motion hearing for March 17th at 8:30.
Just for clarification, is it just a motion hearing? Is it
That's
motion hearing and sentencing?
No, it's motion hearing and sentencing.
Okay.
I have no idea, what will actually come out of that, but I want to make sure that there's adequate and sufficient notice for victim notification.
Thank you.
Mr. Olson, you'll have an opportunity on March 17 at 8:30 on your motions. Okay. Mr. Olson, Tuesday, March 17 at 8:30. Okay. Thank you, everyone. We're done. I'll see everyone then. What? Oh, yes. Actually, we're back on the record. The court will also at this time order remand of the defendant and will return for sentencing / motion hearing on next court date.
Next court date is March 17th at 8:30.
All right, thank you. We're done.
Oh, that'd be awesome.
Okay, we can have it.